So welcome to Landmark Chambers webinar, Bridging the Gap, More Planning Pointers for Property Practitioners. It's a bit of a mouthful. My name is Myriam Stacey QC and I will chair the session today. I'm joined by my colleagues Jenny Wigley QC, Katrina Yates and Heather Sargent, and will formally introduce everyone in a moment. So this is the third session in this webinar series, which is designed to bridge the knowledge gap across two of Landmark's core practice areas, namely property and planning. And we're delighted to see so many of you joining us today and to note such strong continued interest in this series. So I just need to get a few housekeeping points out of the way first. Sure, you'll have heard them all before, so I'll run through them quickly. Your microphones are automatically muted, so you don't need to just adjust your local settings. We very much welcome questions throughout the webinar, and they can be submitted via the text in the Q&A section, which is found at the top or the bottom of your screens. We will try to answer as many questions as possible at the end of the presentations if we have time. This webinar will be recorded and you'll receive a link to the scenario slides and the recording shortly after this event concludes. And if your connection is lost at any point during the webinar, we invite you to rejoin by clicking on the original link. So let's start with the introductions. I specialise in property law and my practice covers both commercial and residential property litigation. I am regularly instructed in disputes involving landlord and tenant, development and real property, where I encounter planning questions on the fringes. And whenever that happens, I am fortunate to be able to refer to my planning colleagues for clarification, confirmation and elaboration. So I join you today in wanting to learn more about Section 106 planning obligations and questions of enforcement. Jenny Wigley QC specialises in planning, public and rating law. She was named as a Planning Woman of Influence 2021, and she regularly appears in planning inquiries, judicial and statutory reviews in the High Court and the Court of Appeal, involving all kinds of development proposals and enforcement action. A recent success in the High Court resulted in the quashing of 37 greenbelt housing sites in the lead site allocations plan. Katrina Yates is cited as a leading property junior in the directories. She's on the Attorney General's A panel, and her practice encompasses all areas of property law, commercial landlord and tenant and land registration. But as she also practices in complementary areas of planning, she's often instructed in crossover cases. For today's purposes, she'll be wearing her property barrister hat. And finally, Heather Sargent also specialises in planning. She's on the B panel and was listed this year as the top-rated junior planning barrister under 35 by the Planning Law Survey and as one of the top 5 juniors overall. Her recent experience includes acting for both developments and LPAs on several central London tall building schemes and the Heathrow third runway litigation. So finally, I'll explain the structure of this session very briefly. In the first section, we'll be asking and answering some general property questions, some general questions that property practitioners may want to ask planners. And they are on 2 topics which have been requested by previous delegates, namely Section 106 planning obligations and enforcement. So that's the quickfire round. And in the second section, we'll be dealing with a few factual scenarios to give practical application to the concepts that we've been discussing. And if we have time at the end, we'll pick up any questions. So now, without further ado, we'll move on to the general questions on our first topic, Section 106 planning obligations. Jenny, question. What exactly is a Section 106 planning obligation? And what purposes can it have?
Well, Myriam, back to basics then. It's a statutory contractual obligation entered into by deed under Section 106 of the Town and Country Planning Act 1990. And I think all references in this talk will basically be to that act. It can be either unilateral or by agreement, and by agreement with the local planning authority. And it can be used to restrict the development or use of the land, to require specific kind of operations, activities or uses to be carried out, and can be used to require the payment of money to the local authority. It's most often used to secure mitigation for the effects of a proposed development, and it's enforceable against successors in title. So it's quite a useful tool in getting planning permission.
Heather, in the first webinar, the speakers discussed how a planning permission may be granted subject to conditions. How do planning obligations and planning conditions differ in scope?
Yeah, so I think probably the key difference is that a planning condition can't be used to require the payment of money. Actually, you can't use it to positively require any kind of consideration. The other probably key difference is that if you have a condition that requires off-site works or works on land that's outside the control of the applicant for planning permission, then usually you'll have to have what's known as a Grampian condition to secure those. So a Section 106 obligation is more flexible in both of those regards. But I think one thing to note is that there is overlap between the two mechanisms. And so if you are sort of pondering which one you should be using, then the government's planning policy guidance advises that if you have got a choice and you could use either a planning condition or enter into a Section 106 obligation, then you should actually use a planning condition in preference to a Section 106.
Heather, you just mentioned a Grampian condition there. The planners will be familiar with that term. The property lawyers may not be. Just quickly, perhaps you could just explain what that is.
Yeah, a Grampian condition is basically where you want to ensure that works on land that, for example, the applicant doesn't control come forward. So, for example, you might need a roundabout to be put in before you can have 600 new houses, occupied without negative impacts on the highway network. So the way that you do it is to have a Grampian condition, which is a negatively worded condition on the planning permission that says, for example, you can't occupy more than the first 100 houses unless and until the roundabout has been provided. So it's just a way to ensure that the chronology works really in terms of addressing the impacts that the new development will have.
Thanks.
And who has capacity to enter into a planning obligation? What are the procedures? Are there any particular formalities for creating them?
Well, Myriam, any person interested in the land to which the obligation relates has capacity to enter into a Section 106. And in practice, the planning authority would want to ensure that all those with interest in the land enter into the obligation and are bound by it. In terms of formalities, it's required to be entered into by an instrument executed as a deed. And it's required to state on its face that it is an obligation, a planning obligation for the purposes of Section 106. It must obviously identify the land to which it relates and the interest of the person entering into the obligation, and obviously the actual local planning authority by whom the obligation is enforceable. So a few formalities, nothing too taxing though.
Mm-hmm. Heather, how does a planning obligation affect the land to which it relates, and how can members of the public check whether a plot of land is affected by an obligation?
Yeah, that's quite straightforward, or at least it should be in theory. The planning obligation runs with the land, so Section 106 expressly makes clear that it is enforceable against successors in title, and it's also required to be registered as a local land charge. I think that's subsection 11 within Section 106, so it should be discoverable basically on a local search.
And Jenny, how can a planning obligation be enforced, and by whom can it be enforced?
Well, primarily it's enforced by the local planning authority who's identified in the obligation. It can be enforced, specifically the statute states it can be enforced by an injunction, and that's, I think, subsection 5 of Section 106. Or by, it can also be enforced by the authority actually entering the land and carrying out the obligations that were required and then recovering the costs of doing so. But it's also worth remembering that it's an ordinary contract in a sense too, so it can be enforced as an ordinary matter of contract law. And because of that, as it's a contract, it often benefits third parties. The mitigation benefits third parties. So it's potentially enforceable by those third parties under the Contracts Rights of Third Parties Act 1999. But pretty much all, well, I think all forms of 106 that I've come across include a standard term excluding those rights. So in practice, that doesn't really happen.
Okay.
Heather, what about if you need to change a planning obligation? Can it be discharged or modified later on? And if so, what is the current procedure?
Yes, it can. So the mechanism is provided by section 106A with a capital A. So, you know, the next section after 106, not a subsection of section 106. Basically, you can't modify or discharge section 1 agreements except through one of two ways. So either you can seek agreement and reach agreement with the local planning authority. That would have to be done by way of a deed of variation. Alternatively, if you can't get the local planning authority to agree with you, then you can formally apply under section 106A for discharge or modification. And it's important to note, I think, that within the statute, there's express provision at section 84 of the Law of Property Act 1925, which most people listening to this will probably be familiar with, is the power to discharge or modify restrictive covenants. That doesn't apply to a section 106 obligation. So the way it works is that there's always the possibility to renegotiate and to agree a variation outside of the mechanism provided in the Act, but you don't have a right of appeal, you know, if you seek voluntarily to agree a variation and the local planning authority refuses. The alternative way is to use the mechanism within the Act. So you have to wait until the relevant period has expired. That is by default 5 years, unless there's an alternative period that's been prescribed. So you can wait 5 years and then you can apply under section 106A. And the test that the local planning authority has to consider is whether the obligation no longer serves a useful purpose. It can modify it if it continues to serve a useful purpose, but it would do so equally well with the modification. But if the local planning authority comes to the conclusion that the obligation does still serve a useful purpose, then it can't discharge it, and it has to determine that it will continue to have effect, you know, without discharge or modification. And there is a right to appeal. The final point to mention on this is that there is a right of appeal against the local planning authority's essentially rejection of an application under section 106B, again, capital B. And you can also use that for non-determination if the local planning authority sits on the application and doesn't give you an answer.
Thank you, Heather. We're going to move on to topic 2 now, enforcement. In the first webinar, Jenny, you'll recall that we heard about the planning control regime. So what enforcement options are available to the local planning authority if a person is in breach of planning control?
Well, there's a number of options. There's an enforcement notice, which I think we'll be talking about quite a lot later. And then there's variations on that or means of bringing that forward. So more urgent versions of that, which are a stop notice and a temporary stop notice. Then there's a breach of condition notice and an injunction. So there are a number of methods. And
what's a stop notice? What's the difference between a stop notice? I mean, it might be blindingly obvious. One's temporary and one's not. But what is a stop notice?
Well, a stop notice can basically bring about enforcement more quickly, because as we'll learn later, an enforcement notice cannot come into effect immediately. Whereas a stop notice can, but there are then potential compensation provisions that come into play with a stop notice.
Mm-hmm.
And Heather, what is the most common form of planning enforcement in the Act?
So by far and away, the one that's used, you know, very frequently compared to all the others is an enforcement notice, ordinarily requiring the breach of planning control to be remedied and requiring the land to be returned to the state that it was in before the breach of planning control occurred. That's, you know, almost always the enforcement mechanism that I'm tasked with dealing with. Occasionally, you know, you do see the other ones, but I suspect because you don't get involved in questions of compensation in relation to enforcement notices, you know, they're the preferred and most common method that you'll come across.
Jenny mentioned that there was stop notices could be used urgently as enforcement notices for other situations. Does it come into effect? Doesn't come into effect straight away then?
No, I think we'll come on and look at this in more detail later, but there's a 28-day period usually that has to be respected before you can actually kind of seek to carry out the actions. So yeah, if in urgent situations, you'd use one of the other mechanisms.
And Jenny, so in practical terms, assuming an enforcement notice is to be served, when is a local planning authority likely to issue one, and how does it work in practice?
Well, it's usually prompted by complaints, really. That's normally when the local planning authority gets involved, complaints by neighbours or competing occupiers, that sort of thing. That's normally what triggers the action. And then quite often the planning authority will seek further information by serving what's known as a planning contravention notice, which can seek information from the owner and occupier. And that's under section 171 capital C of the Act. And then on the basis of that information, the planning authority will consider whether to take enforcement action. We'll have to go through its own constitution to make sure it's got powers to do that. So may need to get authority from the committee or from the relevant officer. And
cutting across you there, in terms of the planning contravention notice, do owners have to reply? Or
yes, there's a penalty, a criminal a fine if they don't reply, or if they include misleading information.
I see.
So that is quite a useful tool to get the information required. And then the local planning authority usually has an enforcement policy which they'd need to have regard to when taking enforcement action, and that will quite often include specifying in a non-urgent situation, specifying some steps to be collaborative and seek to resolve it without needing to take formal action. So, for example, asking the person to stop doing whatever they're doing, or asking them to seek retrospective planning permission for what they're doing. And if either the person refuses to engage or is then ultimately refused retrospective planning permission, then it's likely that an enforcement notice would be served, requiring the breach to be rectified and the land to be returned to its state before the breach. It's important to note that the local authority doesn't have to, it's not required to serve an enforcement notice when there's a breach of planning control. It does have a discretion, and it has to consider whether it's expedient to do so, which does give the local planning authority quite a broad breadth of discretion as to whether to proceed or not. And quite often you get asked whether, from third parties to try and require the planning authority to take action. And that's very difficult. You can judicially review a decision to not take enforcement action, but they're rarely likely to be successful because, as I said, the court's not going to substitute its own view as to whether it's expedient to take enforcement action.
So it sounds as though from the point in time of complaint being made and planning and contravention notice being served and then ultimately decision being made, that could be quite an expansive period of time. Then there'd be a degree of uncertainty as to what ultimately would happen. Is that fair?
That certainly can happen, particularly in a complicated situation. So quite often, the complicated situations you often have are a site which has a whole load of activities going on it that are all mixed together, and it's quite difficult to know whether they've achieved immunity from enforcement over a 10-year period. So you might have a scrapyard with storage, with other things, with other buildings that have been put up, and there've been complaints over different periods of time. That can take a long time to resolve. And of course, if the time elapses and the immunity periods start ticking, then you can get basically planning permission or lawfulness by default, and that can be a problem. So yeah.
Heather, what happens when you are serving an enforcement notice? Can you tell us a bit about the legal consequences?
Yeah, the first one, as you'd expect, is that there's within the notice, there's then a legal requirement to do what the notice is asking you to do, and it will specify a timescale for that. So, for example, say things that have been happening a lot recently, for obvious reasons, you might be a restaurant that's put up a marquee or tried to have some sort of extension to accommodate more people. So it might say, for example, we want this removed within 6 months. But the point that we touched on earlier is that the enforcement notice can't take effect until at least 28 days from the date that it's served, for reasons that I'll come back to when we talk about appeals. So then if you don't, if you fail to comply with the enforcement notice within the specified time period, so your marquee's still up, more than 6 months afterwards, then at that point the local planning authority does have a power to take the necessary steps itself and to recover the costs of doing so from the owner of the land, so it can come in and intervene and try and sort it out itself. Much more usual, I think, again, because obviously the local planning authority then incurs costs that it might not ever recover from the owner. So much more usual is criminal prosecution, because failure to comply with an enforcement notice is a criminal offence under section 179 of the Act. And so what often happens is that there's a right of appeal against an enforcement notice under section 174, and you have to, I think the critical point to note on that is you have to get your appeal in before the notice takes effect, which is usually the 28-day period that I just referred to. So very often what happens, often because the factual situation is so complicated, as Jenny noted earlier, you'll get someone just kind of automatically lodge an appeal, really, because the advantage of doing that is that the notice then doesn't take effect, so it's suspended until the final determination of the appeal, which is likely to be, you know, months, if not more than a year, not infrequently, from the sort of 28-day period. So yeah, going back to Myriam's query about the time that all of this can take to resolve, it can be a really sort of very drawn out process indeed.
Yeah.
And so you're only committing a criminal offence once that suspension of the notice has ended and it's all been finally determined, say at an appeal.
Yeah.
And all those consequences, Jenny, that Heather just referred to, who do they apply to? I mean, I can think of a number of possibilities. Is it the freeholder, the leaseholder, the occupier, or the developer?
Well, first point to note is the enforcement notice is required to be served on the owner. And the owner is defined as the person other than a mortgagee not in possession who's entitled to receive the rack rent of the land, or where the land is not let to rack rent would be entitled if it were so let. That's the definition in the general definition section of the Act at section 336. So it's required to be served on the owner, but also on the occupier of the land to which it relates, and on any other person having an interest in the land. So all those people, I think, probably that you mentioned, Myriam. So anyone basically with an interest which is materially affected by the notice. And the liable person is the person who is the owner at the time of the charge of an offence. So there's a sort of owner offence and there's a person in control offence, both of which can apply under section 179. And in terms of an appeal against an enforcement notice, that can be made by any person having an interest in the land to which the enforcement notice relates. Or a relevant occupier, which means a person who was occupying the land by written licence when the notice was issued and who continues to occupy it when an appeal is lodged. So there's quite a range of people who are potentially affected and who potentially have rights of appeal. And
in terms of the candidates there, are they all potentially subject to criminal prosecution? So the person in control and the owner, or are they able to hide behind each other?
No, they are both the owner and any persons having control can be prosecuted, and I think we'll come back to that. But yeah, they're both potentially liable to criminal prosecution.
So Heather, tell us a bit more about appealing against an enforcement notice. What is the procedure and the potential grounds of appeal?
Yes, so the provision you'd want to look at if you were thinking about this is section 174 of the 1990 Act, which probably someone's already mentioned, but it's the Town and Country Planning Act 1990. The appeal goes to the Planning Inspectorate, so to the Secretary of State, but it's dealt with by the Planning Inspectorate. And there are 7 potential grounds of appeal, and you can take forward as many as you like, but do be a bit careful because some of them are kind of factually inconsistent with each other. So yeah, make sure your argument is coherent, but they are in brief. The first one is that planning permission should be granted for the breach. So basically, you know, you're arguing that there's no reason, looking at the planning merits, why you shouldn't be allowed to continue what you're doing. And then more technical ones. So factually, that the alleged breach never occurred. And then the third one is that factually the alleged breach did occur, but it wasn't a breach of planning control. Then there's a ground of appeal that the period of immunity has expired, so you've become immune from enforcement, either because, so if you change the use of the land, that would be a 10-year period, and for other operational development it can be 4 years. There's also a ground of appeal that you haven't been properly served with the notice, or that the steps that are specified in the notice go beyond, you know, what's actually necessary to remedy the breach. And then the final ground, G, which is usually run just kind of alongside the others, is that, you know, the period specified in the enforcement notice isn't long enough to enable you to remedy the breach. So you might be saying, I can't sort this out in 3 months, 6 months would be a more reasonable period. So can I have longer to address the issue?
Is that common that the notice would have quite a short, unfairly short period for compliance?
I've not seen too many that in my view, are sort of unfairly short, but I think it's fair to say that even where, say, 3 months or 6 months is specified, it seems to be relatively easy for the appellant to gain a short extension. I mean, often there are sort of mitigating circumstances that the local planning authority either might not have known about, or that the inspectorate, or that have arisen, during the course of the appeal. So yeah, success on ground G, which is the final one about the period of time, is more common in my experience than you say sort of an overall success on the appeal on the other grounds.
Thanks.
Last general question for you, Jenny, from me. How can members of the public find out whether the land is subject to an enforcement notice?
Well, again, this is something that is straightforward, or should be. The local planning authority is required to keep a register of enforcement notices and stop notices, and that's under section 188 of the Act. So basically, you just need to inspect that register, which should be online these days. So it's relatively straightforward.
It's easy, yeah.
Heather, what are the options available to a person who's unsure whether a developmental use of land is in breach of planning control?
So if you've got, if you're interested to find out whether an existing development or use of land that's already happening is a breach of planning control, then what you would do is to apply for a certificate of lawfulness of existing use or development. That's under section 191 of the 1990 Act. There's also a sort of sibling mechanism. So if you want to know whether development that you're proposing, or a use of land that you're proposing to bring forward on a site will require planning permission, then of course you can take legal advice. You can also have sort of informal discussions with the local planning authority. But the only way to get a definitive answer about either the legality of an existing use or the legality of a proposed use or development would be to go for a certificate of lawfulness. So section 191 for the existing use, and section 192 if you want to find out about the lawfulness of a proposed use.
Thank you.
Good. I think that takes us to the end of the general questions. So we're going to move on to the factual scenarios. Can we have scenario A, please? Excellent. So this is over to you, Katrina.
Yeah, so Harry's from Bristol, and he's made an offer to buy a 125-year lease of a seaside apartment in Devon, which forms part of a block built in 1995. His offer's been accepted, subject to contract. He intends to use the apartment as a second home at the weekends and in the summer, and he's considering letting it out to holidaymakers on Airbnb for part of the year. The apartments are all demised on common terms. The leases originally contained a restrictive covenant prohibiting the use of the premises other than for private residential purposes, but in the past 10 years, they've all been varied by deeds of variation to allow holiday lets. This is now the main use of the block. Harry instructs a conveyancing solicitor to carry out a local search. Although this reveals a planning permission that is not subject to any relevant conditions, the block is affected by a planning agreement dating back to 1995, which contains a local. There is no evidence of any past enforcement action of any kind in relation to any other owners of the block.
I think the first question is whether the use that Harry is proposing would be in breach of the section 106 obligation, because obviously by this point it seems as though it wouldn't be in breach of the private law aspect of this. And what I would say is that in practice, you're more likely, in my experience, to find this type of restriction, particularly restrictions against holiday lets, are quite common. So they're more likely to appear as conditions to planning permissions. But if for some reason you did have one in a section 106 agreement, then it's pretty clear to me that the proposed use here would be in breach of that, certainly.
Okay, and can you apply to discharge or modify it, Heather? And if so, what would the procedure be for a 1995 obligation? Yeah,
so we've gone through this in outline briefly earlier. So his first port of call, I think, would be to try and agree, voluntarily a deed of variation with the council. And one would hope, to be honest, given, and we'll come back to this when we discuss his prospects overall, but one would hope, given that the main use of the rest of the block is now for holiday lets, hopefully, they would be sensible and potentially agree a variation with him outside of the scope of the statutory machinery. If they didn't, then he'd have to apply formally under section 106A, and if the council was still not letting him discharge the obligation, then he'd have to appeal to the Secretary of State under section 106B.
And what grounds are there? Are there specific grounds of appeal when you're appealing to the Secretary of State?
So the focus is on whether the obligation continues to serve a useful purpose. And I think in terms of his prospects here, the obvious arguments he would be making is, well, you know, the leases have all been varied. So that aspect of it has been dealt with. All the other flats are being used, it seems, for holiday lets already, and there is no evidence of past planning enforcement action having been taken. So if all of that could be robustly evidenced, then on the face of it, I think he'd have good prospects here of succeeding either with the local planning authority in the first instance, or certainly on appeal if he could evidence all of that. I'm not sure that the local planning authority would have, you know, a hugely persuasive case in response.
And going back to timelines then, given that this is important, you know, everyone likes to know what's going on and what's to have as much certainty as possible. Are there specific timelines for appeals that people need to know about?
No, not in this regard. The key thing really is to make sure that you're beyond the initial 5-year period where you can't use the section 106A mechanism, which he would be here plainly because it's 1995, so plenty of time's gone by.
Okay, and if he purchased the premises and used them as he intends, ignoring the planning obligation, what would the risks be?
I mean, the risk is probably of an injunction here, I think, or an enforcement notice. But the risk is that the local planning authority will seek to take enforcement action against him, obviously. I don't know in detail about this, but it's certainly a risk that I assume one could seek insurance against, you know, in the same way that you can get insurance against restrictive covenants. I think that is available, so he could explore that.
Yeah, although it's often the case, once there's a dispute known about, it's harder to get insurance. It's easier to get insurance before the disputes come to life, if you like. Thank you, Heather. We'll move on to scenario B then. If you can have B1, please. Yeah, so Sally, she's the owner of a single dwelling house in an area where there's a housing shortage. And without planning permission, she converts the house into 4 flats, 4 self-contained flats. On the 1st of June, 2021, she lets each flat under 12-month assured short-hold tenancies, so to 4 tenants. And after the tenants move in, the neighbours complain about noise and various other things to do with bicycles and parking. 1st of July, 2021, the local planning authority serves an enforcement notice on Sally and on the occupiers. And the enforcement notice states that they require cessation of use on the basis that there's a breach of planning control, and they require restoration of the building back to a single dwelling. And the steps are required to be taken within 3 months of the notice coming into effect. And Sally immediately lodges an appeal against the notice. So, Jenny, I mean, I note the 3-month period, for example, at the outset. Presumably this is an appeal to the planning inspectorate, as Heather's already explained, and the enforcement notice refers to 3 months. Does that mean 3 months from the date on which it was served?
No, is the short answer. So the required period would be 3 months from the date it takes effect, and it cannot take effect fewer than 28 days following service. So the date for compliance would be 3 months plus 28 days. But here, of course, Sally has lodged an appeal within the 28 days, and the effect of the notice is then suspended until final determination of any appeal.
Okay. And in terms of getting rid of the notice, Heather also explained the grounds of appeal, but on what ground here would you say that Sally's most likely to succeed, and on what basis?
Well, I mean, it's pretty clear here that there is a breach in that there's been a conversion to 4 flats and tenants have moved in, so there's been a change of use as well. And there's no kind of factual dispute on that. And there's also no legal dispute really as to that constituting a breach of planning control. So it would appear that the only real grounds she has are ground A, which is applying for planning permission retrospectively, or ground, and probably rather than or, and ground G, which is the time for compliance, because it may well be that she needs more than 3 months to get the tenants out and to do the conversion works.
Yeah, okay. And in terms of getting the tenants out, we'll come on to that in a moment, but if we can focus on the application for planning permission, so ground A first. I mean, is there anything she can do or say to improve her prospects of success in relation to that?
Well, one thing that's, you know, we note from the facts is that there's a housing shortage. So you've got this large single dwelling house. It must be pretty big if it can accommodate 4 flats, I would have thought.
Yeah.
So I would have thought that in terms of the council's housing needs, the conversion to 4 flats would help meet those needs. And so that would be a strong point in favour of an application for planning permission. And that's something she should press quite hard. In terms of dealing with the downsides and the complaints, so the noise, the bicycles and the parking, there may well be either conditions she can offer to accept or offer a Section 106 obligation to deal with some of those issues. So for example, you know, for noise, there may be something she could agree to do in terms of soundproofing of the flats, or you know, putting in wall insulation or whatever, so or windows. So there could be issues about remedying noise effects, which could be done by a Section 106 agreement. Similarly, in terms of parking and bicycles, there could be an agreement not to use the railings for bicycle storage, for example, or for some of the occupiers not to have parking permits. That type of issue can be dealt with by a Section 106 agreement.
Okay, and can all this be the subject of discussions, or does she have to go straight to making an application for retrospective planning permission? Can she, for example, go through a pre-app process in order to kind of see what the council would be minded to, or local planning authority would be minded to accept?
Well, of course, in this situation, she's got an enforcement notice served against her. So she will need to make that appeal within the 28 days and lodge a fee. You have to lodge a fee for a ground A appeal as well. So there won't be much time to do that within, you know, before lodging the appeal, and which effectively makes the application. But I would have thought that, you know, after the lodging of the appeal, there's certainly scope for Sally to enter discussions with the local planning authority and seek to agree a position, which will then go before the inspector. Of course, it's not the planning authority who is granting or refusing the application at that stage, because it will be it's the inspector who takes the decision. But it will certainly help her case if she's agreed with the local planning authority draft conditions or a Section 106 agreement to deal with some of these issues.
Okay, thank you. Okay, let's just flip the scenario slightly. Same basic facts as we've just seen on that slide, but can we have scenario B2, please? There you go, so same background, but imagine, what if she misses the deadline to appeal against the enforcement notice? And what happens on the 1st of November, she and her tenants are prosecuted for failure to comply under Section 179. And on the 2nd of June 2022, so 7 months or so later, she serves a notice on each tenant under Section 21 of the Housing Act 1988 to determine their tenancies, giving them 2 months' notice. So recall that the tenancy commenced a year earlier on the 1st of June 2021. And the trial of the prosecution is listed for the 10th of June 2022. And at that date, all the tenants are still in occupation. So first things first, Jenny, what's the effect of the failure to appeal? Is the timeline of the essence, or can she extend time?
It's pretty absolute, that deadline. It's a deadline, and an appeal has to be brought by written notice within, you know, before the notice takes effect. Now, the notice will usually take effect within 28 days, although a longer period could be specified. But it's in all notices I've come across, they use the minimum 28-day period. So unless she's brought an appeal in writing within that 28-day period, she loses the right to appeal. Okay. There's no power to extend time.
And does she have any defence then to prosecution? What's the nature of her defence?
Well, she's the owner, so she does have a potential defence under the Section 179. But that well, there's 2 potential defences actually. One is about service. So if she had been unaware of the notice, she does have a potential defence, but that only applies if A, she wasn't served with it, so the service provisions weren't followed, and the notice was not on the Section 188 register. So even if she was unaware of it, but those 2 things happened, she then wouldn't have a defence.
So the fact that it's on the register is effective, is sufficient, even if she wasn't.
Yes, sort of deemed notice effectively. there's another defence which is probably more applicable here, because it appears here she was aware of it anyway, and that is that she has done all she could be expected to do to comply with the notice. And obviously that's quite fact sensitive, but that is a potential defence. And the courts have generally interpreted that as meaning all she can reasonably be expected to do to comply.
Okay. And that depends, you say, on the circumstances. Okay,
Yeah.
so what I was
and it would be, sorry, just to add there, in terms of, you know, at the prosecution, because it's her defence, it would be her burden of proof in relation to that issue. But that burden of proof would be on the balance of probabilities rather than reasonable doubt. So that she needs to establish that.
Yeah. So, I mean, what's going through my mind from a property law point of view,
yeah,
this is where one has a bit of overlap, I suppose, because she served a Section 21 notice under the Housing Act, but she didn't serve that notice until the 2nd of June 2022. Whereas you can serve a Section 20, although the Section 21 regime is the ability to get tenants out after the end of a fixed term, you can serve a notice earlier so as to expire when the tenancy, as long as you're not asking for possession before the term expires. So she didn't arguably get on with it early enough. She could have served it back in April 2022. It would have expired coincidentally, if you like, with the end of the term, by which time she could then have brought accelerated possession proceedings and had them running already at the time of the prosecution being listed. So I assume that would be part of the factual, you know, picture, if you like, that would be relevant to deciding whether she's done everything she reasonably can.
Yeah, definitely, it would be part of the factual picture. Of course, the actual date of the offence would probably be earlier, wouldn't it? Because she was prosecuted on the 1st of November 2021. So formally, it wouldn't affect what she could have reasonably done by then.
No.
But it would certainly be part of the factual picture, I think.
Yeah, and equally, she could also, what strikes me, she's relied on Section 21, which is getting them out after the end of the fixed term. But given the noise complaints, she could have potentially served a Section 8 notice relying on grounds in Schedule 2, which is nuisance annoyance, where you don't have any notice provision. This is all subject to COVID regulations, but that's another way of getting them out during the term. So again, that's where I would imagine one might need to refer to property lawyers in order to see what the evidence can.
And I suppose if there were any other breaches of the lease, so if she hadn't been paying her rent or something, you know, the tenants hadn't been paying their rent, that may have given her a right to get rid of them, I suppose, would it?
Well, quite that's another ground that she could potentially rely on. It's all very fact specific. Admittedly, those grounds, the Schedule 2 grounds, those tend to be discretionary, so it would all depend on the facts and the circumstances. But if we're talking about what a person can reasonably do, she should, I would have thought, be looking at the facts, looking at the complaints, digging into them and seeing what evidence she can gather together in order to try and secure possession as quickly as possible. And what she's done on the face of the slide isn't, it would seem to me, the maximum, frankly.
Yeah, exactly. And also, I mean, I mentioned that, you know, whilst the offence would have been charged earlier because it was the 1st November 2021 was when the prosecution was brought, there is the possibility and quite high likelihood that the council could recharge the offence on an ongoing basis if she still doesn't act, because under section 179(6), further offences can be charged in respect of subsequent periods of being in breach. So even if she could sit back and say, well, there was nothing I could do by 1st of November, it would definitely be prudent to do it as soon as you can, because otherwise you're at risk of further offences.
Okay, that makes sense. Now, quickly, just on this slide, we've got just a couple more, and then we've got a few questions before we see we're 1 minute before the end. We'll run over by about 5 or 10 minutes if people want to stay. But turning then to the tenant's position, Jenny, are the tenants guilty? Because the notice was also served on them. So are they guilty of an offence? I think the answer to that is yes, because we've covered it. But yeah, their defence, what's the nature of the defence that they'd have? Is it the same as the owners, or is it different?
No, it's not, because this is the sort of person in control offence. So it's a different limb of the section 179. It's section 179(4) and 5, and because they're in control of their land and they have an interest in the land, and they are carrying on activity which is required to cease, namely occupying or using the land as for flats, then they are in contravention and guilty of an offence, and they don't have the do all you can reasonably do defence. They do have the service defence, so if they hadn't received the notice and it hadn't been served on them and it wasn't on the register, then they potentially have that defence, but that's the only defence open to them.
Okay, so there's no obligation on them to, or is there? They have to cooperate, presumably, because
Yes.
although they don't have to do all they reasonably can do.
They would have to do, obviously they can't be prosecuted for failure of the other 3 flats, but in terms of their own continuing activity by continuing to use their flat, they would be vulnerable to prosecution in relation to that.
And what kind of sentences would they be likely to be faced with?
Well, their sentences would probably, I expect, be significantly less than against the owner, because I mean, generally it's open-ended. It's an open-ended fine. It's an unlimited fine. The sentence that's available on summary conviction or conviction on indictments. There's no limit to the fine, and the criteria that are applied. Well, statutorily, the court's required to have regard to any benefits, any financial benefits that have accrued as a result of the breach. So that would almost definitely apply to Sally, because she's been receiving rents from these flats. So her sentence would most likely be increased for that reason. And I expect the court would have some sympathy for the tenants, particularly if they didn't know or were not in a position to find out easily about the breach of planning control. I expect they would have some mitigating circumstances, and that their fines would be significantly less, if at all, if they'd acted quickly. Yeah.
And what about the noise in terms of Sally? So if she's paid rent, it's a commercial activity, that would be taken into account. But what about the noise issues and complaints? Is that something that would weigh in the balance when?
Yes, potentially. I mean, potentially all relevant circumstances would apply. And there are cases where the degree of planning harm has been a significant factor, particularly again where the person who the complaint is against knows about that, knows that there are complaints about it and has been asked to stop. If there are significant planning harms caused by that continuing breach, then that would certainly be an aggravating factor and could increase the fine.
Okay, and actually, finally, before we leave this, what strikes me is the tenants. You say the court would have, or there'd be sympathy for them. I mean, they might have an independent property claim against their landlord if they're required to leave before Sally secures right to possession against them. They could bring a claim against her for derogation from grant or breach of quiet enjoyment, but that's obviously separate.
I wonder, in that situation, would they be able to claim back the fine from the landlord?
Well, potentially, exactly. It would be damages resulting from
exactly.
Causal connection there. Great. Okay, so those are the scenarios. We've got a few questions. I'm conscious we're a few minutes over time, but I hope that's not too problematic. So just looking at the questions, sorry. There's a question here from somebody about Section 106 obligations. Heather, are unilateral undertakings capable of being varied in the same way that Section 106 agreements are?
I think the answer is yes. I think the key to that one is a Section 106 obligation. So where the Act is referring to a planning obligation, that encompasses both a Section 106 agreement, which is bilateral between the local planning authority and the person offering it, and also unilateral undertakings. So it is a bit peculiar because, if it's a unilateral undertaking, then it is odd to then suddenly be talking about having to get the local planning authority's agreement. But I can't see anything in the wording of the Act to indicate that there's any difference actually drawn between unilateral obligations and bilateral agreements in terms of the operation of Section 106A and B.
Okay. And we've got another one here. I'm just going to read it out, and whoever wants to answer it can take it. Can a Section 106 be attached to a permitted development permission, e.g. to require payment of compensation to decanted top floor residents in relation to an upward extension? Anyone?
I think the 2 points I'd make on that. First of all, it is odd to be talking about Section 106 obligations in the permitted development context, which we've not really touched on this morning. But the whole point of permitted development is that you're not actually dealing with a full-blown grant of planning permission, because the statute's already given you your planning permission, so you're just dealing with concerns around prior approval. I mean, I think it's right that you can, theoretically, you could enter into a Section 106 obligation, even if you weren't dealing with an application for full planning permission. You can theoretically do that. Section 106 isn't confined to applications for planning permission. But the issue that I see here is that under Section 106 1D, you can be required under a Section 106 to pay sums, but you can only be required to pay them to the authority. So I've never myself come across a Section 106 being used to essentially require payment of compensation, to private individuals. And I don't think that would be, on the face of it, that doesn't fall within the scope of Section 106 itself.
Okay, that's clear. Thank you. Good. Well, that takes us to maybe 5 minutes over. Thank you all for joining us today. We hope you found the webinar useful. Before you get on with the rest of the day, just want to remind you that you'll be receiving the link for your recording later today, and we encourage you to provide feedback to us by replying to that email. It's always extremely useful to us in order to enable us to improve and to continue to provide content that is of interest to you. So please do take the time. And in particular, if there are any topics that you would like to hear about in the future, let us know. And then pending that, we look forward to seeing you later in the year for another Bridging the Gap webinar. Many thanks and enjoy your day.